Hi, my name is Nana Yoga Gross, and I am an immigration paralegal for Her Justice. Her Justice stands with women living in poverty in New York City, recruiting and mentoring volunteer lawyers to provide free legal help in the areas of immigration, divorce, and family law. Today, I'm going to talk through a great and important immigration update, which will help U visa petitioners attain work permits. A work permit is a document that shows employers that an immigrant has the legal right to work in the U.S. If someone has a work permit, they can also get a Social Security card and number. This video provides general information, not legal advice. If you're interested in applying for a U visa or have specific questions, you should speak to an experienced immigration attorney about this process. Let's start with the basics. A U visa is temporary permission from the U.S. government, U.S. Citizenship and Immigration Service, or USCIS, for victims of certain types of crimes who are not legally present in the U.S. to stay in the country for 4 years. The technical term for someone with status who is in the U.S. is U non-immigrant status, but we will call it a U visa for short. A U visa is filed with USCIS on Form I-918. To get a U visa, a person must also file Form I-918B, which is a document from a law enforcement agency that certifies the person cooperated in an investigation about the crime. In addition to those forms, a lot of evidence needs to be provided to USCIS. If granted a U visa, a person is generally also eligible for the following benefits: Employment Authorization Document, or EAD, also known as work permit, and also something called deferred action. What is deferred action? USCIS is not allowed to give out more than 10,000 U visas each year. Because they get many more than 10,000 applications every year, there is a waiting list for U visas. People who apply for a U visa will not be given a U visa right away, even if USCIS states that they are eligible for a U visa. People who are found to be eligible for a U visa are put on a waiting list and will be given a temporary status called deferred action. Getting deferred action means that USCIS is aware that you are physically present in the U.S. and that you are eligible for a U visa, but you cannot get one right away because of the cap of applications. When a person gets deferred action, it generally means that the U.S. government will allow you to work lawfully and will not try to deport or remove you from the U.S. When a person is found to be eligible for a U visa, it means that they are also on a pathway to lawful permanent residence, also known as having a green card. Once a U visa is approved, certain family members, including those living abroad, may also be able to get lawful status in the U.S. It currently takes approximately 5 years for USCIS to decide who is eligible for a U visa. Until June of 2021, USCIS did not issue work permits to applicants until the 5-year process was complete. Without work permits, survivors have no way of obtaining lawful employment, cannot obtain Social Security numbers, and struggle to support themselves and their families. Here at Her Justice, alongside other organizations throughout the U.S., we have advocated for faster issuance of work permits for survivors for years because we know how vital they are in helping individuals achieve economic stability and safety. We are very happy to share that USCIS announced on June 14, 2021 that it would begin a process for granting work permits and deferred action to certain applicants and, in some circumstances, their qualifying family members more quickly. After June 14, 2021, USCIS will review U visa applications for certain basic requirements: that the I-918 petition for U visa status is properly filed, that the I-918B certification from law enforcement is properly filed, and that the person is not a public safety or national security risk. If these requirements are met, then the person's application is deemed bona fide, and USCIS will issue a work permit and deferred action. The person will not have to wait 5 years. I will now tell you a few things that we know about this new policy. This new policy aims to provide temporary employment authorization and deferred action, a temporary protection from removal from the U.S., to applicants who have been waiting or may need to wait 5 years or longer to secure their actual U visa. USCIS will be making bona fide determinations, which we will call BFDs for short, for U visa applicants with pending U visa applications and those who will be filling these applications moving forward, plus their qualifying family members who are physically present in the U.S. This policy does not apply to applicants who are applying for a U visa from abroad. If an applicant has a pending U visa application, they do not have to do anything at this time. USCIS will be conducting BFD reviews on all pending U visa applications to determine if the applicant and any qualifying family member qualifies for interim employment authorization and deferred action. You might have some questions such as, when will USCIS be issuing these BFDs? As of now, this is unclear. There is a current backlog of over 270,000 U visa applications. Therefore, we expect it to take several months at a minimum to perform these reviews. We do know that BFD will not be issued to any applicant until USCIS has conducted their background and security checks. You might be asking, how long will BFD work permits and deferred action last for? USCIS stated that BFD work permits and deferred action will be granted for up to 4 years, with the possibility of renewing in 4-year intervals afterward until the U visa is granted. And what if an application does not get a BFD? Is it still possible to be approved for a U visa? Yes. If there is no BFD, that only means the applicant must wait for the full approval of their application. The applicant's case moves on a separate track and will be reviewed in more detail by an immigration officer in the future. If the officer needs more information to approve the application, they will send a request. However, in that situation, there will be no work permit in the meantime. Can you non-immigrant applicants with criminal histories be approved for interim work authorization and deferred action? Petitions filed by individuals with a criminal record will receive very careful review by USCIS. When reviewing an individual's petition, USCIS will assess whether that individual poses a risk to national security or public safety. Can family members get an EAD or deferred action under this new policy? Yes. Depending on the circumstances, some qualifying members who are physically present in the U.S. can receive an EAD or deferred action. Thanks for listening. Her Justice has all of this information on our website at www.herjustice.org/immigration updates. We will keep this page updated as we receive more information.